Hi everyone, this is Ask the EFF, and so we'll let them in go.
All right. Thank you, everybody. Thank you for coming out. It's always a pleasure to be back here at BSides San Francisco for our Ask the EFF panel. This is a panel in which you can raise any questions that you'd like to ask our collection of staff. We'll do introductions in just a second. I'll start with myself, actually. I am Kurt Opsahl. I'm the Deputy Executive Director and General Counsel at the Electronic Frontier Foundation. And one of the things that I work on there is our Coders' Rights Project. And that is a project where we work a lot with security researchers to advise them on the risks associated with doing the research and with disclosing or going public with the research. And we try to help people sort of navigate those risks, both for research that they are planning to do in the future, to try and understand the risk with doing it, and then if the research has already been done and they want to disclose it, how to do so in a manner that minimizes admitting felonies. So I'm happy to take your questions in general about coders' rights, but one of the things we like to emphasize with these panels is that we do provide legal advice to security researchers, but this is not the place for that. You would want those conversations to be protected by the attorney-client privilege, and even though everyone here is very lovely and I'm sure understands about confidentiality, this is not the place to have a privileged conversation. So if you have a question about your particular situation, that's something to talk to us about privately in a different forum. However, if you have general questions about computer crime law and hacking, then this is a fine place for that. And so that's my intro, and we'll go down those to let you meet the rest of our staff.
Hi, my name is Cooper. I am a senior staff technologist and security researcher on EFF's new project, the Threat Lab. Threat Lab is a project for us to research targeted threats against at-risk populations. So this is like journalists, human rights defenders, activists, dissidents in the US and around the world. And what this means is looking at a lot of things like state-sponsored malware that targets journalists and activists, police spying technologies such as cell site simulators, also known as stingrays, license plate readers, and other technologies that police use to spy on people locally and abroad, and malware such as spouseware, which is the type of malware that people, abusive partners install on their partner or lover's phone to spy on them and get information about them. Most recently, notorious for the El Chapo drug lord trial, it came out that he had installed spouseware on his girlfriends and also lieutenants' phones to spy on them and make sure they weren't ratting him out. But it turned out that his sysadmin had turned and was working with the FBI, and they were able to use all of that information that they were getting from the spouseware to help with the case against El Chapo. But it's also very bad for other reasons because it's abusive and terrible. So that's what we're working on. I've mainly been studying MC catchers and cell phone networks for the last year or so, working on a project where the goal is to actually secure the phone networks and make MC catchers a thing of the past, to make it so that they can no longer exploit the flaws that they use to locate people and potentially spy on their conversations. Previously, I worked on the tech projects team working on some of our projects like Privacy Badger, and so I have a lot of knowledge around that as well, web tracking and things like that as well.
Hi there, I'm Andrew Crocker. I'm a senior staff attorney at EFF. I work with Kurt on the Coders' Rights Project that you heard a little bit about already. I also do a mixture of national security, privacy, and InfoSec stuff. So some of the things on my docket recently, worked on a brief filed with the Indiana Supreme Court about compelled cell phone decryption and whether it violates the Fifth Amendment. So that the question there is, can you be forced to unlock your cell phone if the government gets a warrant to it and you say, I don't want to unlock it, can you be forced to do so? Does it matter if it's a passcode or if it's your face or fingerprint? Those are all things we could talk about if you're interested. Also work on our long-running cases against the NSA, suing over warrantless wiretapping, collection of telephone records. Our flagship case is Jewel versus NSA. It's been going since 2008. We're, after several courses of, up to the appeals court, back to the district court, we're back in the district court. We're mostly focused on conduct that the NSA engaged in before the passage of the various wiretapping laws that authorize this kind of behavior, and just looking at things that happened when it was just authorized by President Bush. For a long time, the government has gotten in our way and said, this is secret stuff, you can't even litigate about it, you can't see it, the court can't see it. And we just got a ruling in another case from the Ninth Circuit Court of Appeals here in San Francisco earlier this week, which says that's wrong, and actually the Congress has passed a procedure for dealing with secret evidence, and it can be used in a lawsuit, it can be shown to the judge, and the judge can determine whether to use it. And we think this should be a big shot in the arm to our Jewel case, and we're sort of looking forward to a hearing at the end of this month. And then the last thing in NSA land is Section 215 of the Patriot Act. That's the law that was being used by the NSA to collect everyone's telephone records in bulk for over a decade. You may remember that from Edward Snowden's debut in The Guardian. That's up for renewal in December, and so we're focusing our efforts on trying to get it narrowed, get some good reforms to it, and I will let India talk about that in more detail.
So my name is India McKinney. My title is Legislative Analyst, and basically what that means is I'm a lobbyist for the EFF. So one of the jokes I like to make internally is that the principles of social engineering are actually very similar to the principles of persuasion to be used in lobbying, only instead of trying to get your account information or your social security number, I'm trying to convince you to vote the way that we want you to vote, or to sign a letter, or to ask some questions, or to do the oversight that EFF and its members think that Congress should be doing. So one of the things that I'm working on, as Andrew mentioned, is Section 215 is up for reauthorization by the end of this year, which means Congress is going to have to work on this. It's challenging at the moment because Congress, the same committees that will be responsible for renewing or reauthorizing or reforming Section 215 are a little preoccupied by some other things that are happening in the intelligence and judiciary sections at the moment. So part of what my job is there is also education, and is also reminding them that this is a thing you're going to have to pay attention to. Here's some paper, here's some thoughts, here's some questions you can ask when the FBI or the NSA come to talk to you about what they think the reauthorization bill should look like. We don't agree. Maybe you should talk to them about these things. Another big part of my portfolio right now is the possibility of federal legislation dealing with consumer data privacy. There are a number of state bills that have happened across the country, both in California, Illinois, Vermont, and there's some others that are in the works. And so the question is whether or not there is going to be a big, comprehensive federal consumer data privacy bill, and will this bill preempt what's happening at the state level? What that would look like if it does, what it would look like if it doesn't, what does federal data privacy mean, what should it mean, what do these words mean, how are you defining these words? When you're creating a piece of legislation, especially for something that the federal government has not looked at before, again, there's a lot of education that has to go into that. And that's when we really rely on both the attorneys, but also the awesome engineers and tech projects people to talk about what personal information looks like. It's not just your name and your address. It can also be your IP address. It can also be any other number of things. And most of Congress doesn't have a tech background. And so that's a huge part of the value add that we provide. And we've consulted with some of the individual senators and individual representatives on some of the legislation that they're working on at the moment. If it's public and been introduced, I can talk about it. If it's not public and hasn't been introduced, then I can't talk about it until then. But that is something that we're working with, and we're in conversation with a lot of members, because that's my job.
Okay. Hi, I'm Alexis Hancock. I am a staff technologist at EFF on the tech projects team. I am the lead dev on HTTPS Everywhere web extension. Yeah, yay, fans. Overall, if you don't know what the extension is, basically we use a magical technology called regex to help people upgrade from a unencrypted connection to a encrypted one on the web. It's mostly available on Chrome, Firefox, and Opera. It is also packaged into other browsers as well, like Brave and Tor. So we often work with them to launch and deploy this extension on these platforms, mainly straightforward as far as what we do as an extension, but also there's a community platform as well that is open, so please come look at the contribution docs and see where you can help with. We're always open with people to help us maintain our rule sets, go over testing infrastructure, and also the code base itself as a web extension. The web extension ecosystem is fairly easy to grasp once you look at it. So if you're familiar with web technology and are interested in helping us develop with the extension, I would appreciate it very much. We're open on GitHub. Feel free to open issues if you have them. We often try to respond as much as we can for pending issues. And as far as like the future of HTTPS, my main goal is to not have HTTPS everywhere exist one day, and that browsers will just automatically have HTTPS everywhere. But until then, I'll be working on the extension.
Hi, my name is Alex Moss. I'm another attorney at EFF. I focus on intellectual property, and EFF does work in the whole family of IP and copyright and trademark, but I focus or hyper-focus even on patents. And most of what we do, of course, isn't helping people apply for patents. It's mostly helping people deal with patents, either people who have been threatened, people who have been sued, and trying to figure out how to help them defend themselves. And we also do a lot of work in trying to make the law better, both through bringing lawsuits and in weighing in as an amicus, and also through trying to talk to policymakers. And in particular, lately, for a long time, EFF has been working on issues around the eligibility of software for patents and in what circumstances software should be patentable. For a long time, until the 1990s, there were actually no software patents. And a decision by an appeals court then made them patentable, and it took a long time, but the Supreme Court finally took a case and considered the eligibility of software, and they issued a great decision called Alice versus CLS Bank, and they really narrowed it down and said you can't just add a computer to some basic idea. And unfortunately, since that decision, there have been efforts a lot to start even changing that, both for the courts and also to actually change the law, to change the Patent Act, which has had this same language since 1952. So we're doing a lot, thanks to Indy and her team, to try to prevent that from happening. One of the things we like to say is that if people really believe in patents and having good ones, you should want to kick out the stupid ones. It's like if you have a party and you kick out the bad guests, it doesn't mean you're anti-party. It just means you want a party that doesn't suck. And so that's what we try to do is try to get fewer patents that suck at the party.
All right, so the main format here is we answer your questions. So hopefully, now that you've heard from my colleagues here, that has given you some ideas. So if you have a question, just raise your hand and we'll call on you. And all right, first question.
Is there any path to a federal data privacy law that doesn't suck?
Yes.
What does that look like?
So
What I'm scared of is that they're going to write a law that's watered down and compromised and overrides the state laws and will actually be weaker. How do we not have that?
Before you answer, just repeat the question.
Right. So the question
Mike.
is there any path to a federal data privacy law that doesn't suck? Because the concern is that the federal law will be weaker than any of the laws that the states have passed. That's actually the million-dollar question. And you previewed my answer, which is a way that it doesn't suck is if it's a floor, not a ceiling. There's a lot of other stuff that's already happened. HIPAA is a federal law that states build on top of. There's a bunch of different environmental regulations that the federal government has created a floor, and California has additional standards on top of that. There's a lot of examples of how this can work and work really successfully, and industry hasn't failed. So we still make cars, and they still get sold in all of the states. You still go to the doctor, and the rules still apply. They figured it out. There's a lot of different ways that it could suck. There's ways that it can't. But right now, it's just really a big question. And so now we play our game.
All right, thank you. I guess we have a question here and then back there? Or back there first and then down here, okay.
It works really well as a follow-up. I was just wondering, with GDPR happening, is that something that we can use to build our own federal privacy law? And have there been any big wins or any big surprises around how GDPR has affected this country and our privacy systems and so on?
Well, the GDPR was fairly huge. It came into effect on May 25th of this year. Last year, that's right, of 2018. Time does fly. So the General Data Protection Regulation, or GDPR, is a European regulation. It applies to people who are in the European Economic Area, which is essentially the EU. But because many companies, especially the US-based internet giants, have lots of European customers, it also has had a tremendous effect around here. And in some cases, it has been that companies will apply aspects or all of the GDPR just in general, because it's easier to just apply it than to subdivide as to who is who. There have been a couple of prominent people who are companies that have said no, like the LA Times for a while, just like if your IP came from Europe, you were just blocked because they didn't want to deal with GDPR compliance. But the temptation to do business with Europeans from the United States has brought GDPR compliance to the US for at least the larger companies who have an overseas reach. It also has inspired the question of, like, should we have something like the GDPR inside the United States? Very prominently here in California, there is a California privacy bill that was passed last year, will go into effect January 1st, 2020, but it was passed because well, somebody put a ballot proposition out there to say, to add some data protections. The legislature worked out a deal. If they passed some legislation, then they would withdraw the ballot thing. And so the legislation was passed. But the whole idea is it will get amended heavily before it goes into effect in 2020, so we don't actually know what is that going to end up. So I guess the upshot to the question is, yes, the GDPR is having an effect here. Where that effect will roll is still being determined. All right, a question here.
Okay. I've had a hard time keeping up with all of the biometrics and force or not force people to unlock phones. So if we could get like a TLDR on that, that would be great. And then if it comes to pass that people cannot be forced to unlock their phones via biometrics, where does that land with regards to how do we essentially hold law enforcement accountable on that? Because it's one thing to strong arm someone and be like, you must enter your passcode, but like hold my phone up to my face and I can make a dumb face, but it's still gonna unlock. Like, how do we make sure that the use of biometrics isn't being against people's wills?
So it's a good question. So just to maybe recap the sort of baseline law that we're talking about here, the Fifth Amendment protects you against self-incrimination, so you can't be forced to testify against yourself. The way that that's been interpreted over the years is you can't be forced to tell the government, tell the police, something that comes from the contents of your mind against your will. So you can't be forced to answer questions you don't want to answer if they're self-incriminating. And that then has been extended to things that are nonverbal. So you know, you can't be forced to nod yes to a question that you can't answer, that you can't be forced to answer yes to. So that's where this law is grounded. In the last 10, 15 years or so, the question has arisen of whether that includes being forced to tell the government and police your password to a device or type in a password. And the law is still evolving there, but I think the leading opinions, and certainly EFF's view, is that would violate your Fifth Amendment rights because it forces you to recite the contents of your mind to tell your passcode or to type it in, which is essentially like writing it down, right? The way that courts have treated biometrics is actually very different, and it comes from a different set of law, you know, from pre-digital context, where you can't be forced to give the contents of your mind, but you can be forced to do physical things. So you can be forced to put your finger on a fingerprint pad to be fingerprinted. You can be forced to stand in a lineup. You've seen The Usual Suspects, that scene where they all recite the same line. That's not a violation of their Fifth Amendment rights. You can be forced to give blood. have your photograph taken, all of these sorts of physical attributes that can be taken from you or be forced to do them without violating your Fifth Amendment rights because it doesn't come from the contents of your mind. So courts have generally looked at biometrics and said, well, that's like being fingerprinted, or it's like having your photograph taken because you're pressing your finger on the phone to unlock it, or you're holding your face up to it. It's sort of a weird outcome, right? That depending on how you choose to lock your device, you either have this pretty strong constitutional protection or you don't at all. And it's not clear how we should get to a different ruling, but it seems wrong that there's not this functional equivalence. There was a decision just earlier this year in January from a magistrate judge in Oakland in a federal court who said basically that because it is functionally equivalent, whether you use a passcode or whether you use your face, they should be treated as such, and therefore the Fifth Amendment should protect it. Unsurprisingly, the government has asked that to be reviewed. So the way that works is it goes to the next level, which is the district court. And I believe there's a hearing in April. So we're watching that very closely. But it's really in flux. And your second question about how we can make sure that the police are held to account is a really good one. How this happens on the ground is always very different than the way it is sort of hypothesized to be by a court. We have a whole area on our website, surveillance self-defense, which is sort of a know your rights training. And so you know exactly what you're entitled to do. Are you allowed to say no when you're being asked to consent to search? And so I think at least a part of the answer is raising awareness of what the rights are, what the law holds. Right now, the law does seem to be protecting passcodes more strongly, and so depending on your threat model, of course, you might choose to use a passcode if that's a concern of yours.
And just a quick addition to that, internationally speaking, like not every country has a Fourth or Fifth Amendment, and not every country even necessarily follows the rule of law. So you might have very different concerns in a country like that may be happy to force you to give up your password or put the phone in front of your face. And that requires separate threat modeling and separate thinking, right? And in those cases, you may not want to use biometrics at all, but you may also need to be cognizant of the fact that they may be willing to go to much further lengths to get your password, and maybe you just want to use biometrics and not keep sensitive information on your phone. To whatever degree that's possible.
All right, thank you. Question in the front.
Is the EFF doing anything to address the impact on the internet, especially marginalized communities, in the wake of SESTA going into effect?
Yes. So we are challenging the SESTA-FOSTA allegation, saying that it is unconstitutional. So we're bringing a court challenge to that. And we are hopeful that can at least either invalidate it or significantly scale back the effect of it. We've also been in some conversations with folks who have been, is everyone familiar with SESTA-FOSTA? Should we give
Okay,
no?
I heard some news.
Okay, so SESTA-FOSTA is a bill, a law now that it was passed. There was two different bills, one called SESTA, one called FOSTA, so we just sort of call it SESTA-FOSTA now. And it was trying to, the proponents at least were saying that this was trying to stop sex trafficking on the internet, but was doing this in a very ham-fisted way that was potentially going after the communities that were providing support to people in the sex work industry, platforms upon which things, whether it was ones in which there were transactions or ones that were providing other forms of support and care, and it kind of has put a chilling effect on a lot of speech around the internet because of the potential for the platform to be liable. Do you have something to add, or?
My mic is gone, but in terms of impact, it's had impact collateral damage on online dating, on trans rights discussion groups, like so many different marginalized communities.
For those who can't hear, that was saying that it's had impact on discussion groups, online dating, trans rights discussion groups, a lot of things that really are protected speech are the kinds of things that should not be chilled in this manner. And so it is a terrible law. It is a classic, I think, of Congress where it was put forward with the, we're doing this to protect the children and keep everybody safe from the bad guys, without much thought about it and without much deep analysis. And a lot of the companies, the prominent companies, didn't put up much of a fight against it. They had political capital to spend elsewhere with a lot of privacy scandals.
It wasn't so much that they didn't put up a fight against it, they actively endorsed it. We spent a lot, I personally spent a lot of time lobbying against this bill last summer. And one of the conversations that we had around this a lot, we explained all of the issues, we explained the collateral impact, we explained all of this stuff, but there were two things that were happening that were working against us. And one was that there was very little engagement of the public around the whole idea of Section 230 and the Communications Decency Act, Section 230, that deals with speech on the internet. We couldn't get traction. We were doing action alerts. We were doing everything that we could do to get people engaged and involved, and we just couldn't connect. We couldn't click somehow. Right after it passed the House and it was going to get passed by the Senate immediately, all of a sudden Twitter blew up around this idea, and we were like, guys, I needed this 2 months ago. So there's that. The other thing is talking to members of Congress, we explained the whole issue and why this is important and why this is necessary and why this bill that you're looking at, why it is bad. Here are all of these, let me list out for you all of the reasons that this is bad. And they would listen and they're like, I totally agree with you, but it's child sex trafficking and I can't vote against that. But if we do something similar with like guns or opiates or terrorism, we're totally with you on that. And it's like, I don't believe you. But that's one of the other things that I'm continuing to work on to guard against. But that's actually something that we are going to need help from the bigger, wider community, is when we start trying to get traction on something like that, we need people to pay attention and call their members.
And one of the other things about this bill is that it's actually had the effect of driving sex workers who aren't being trafficked, who are doing this independently and who are doing it consensually, underground and off of these sites, which were very important for their safety, which were very important for vetting their customers, and making sure that they could operate safely. And it's driven lots of them back into pimps and actually being trafficked. So it's had the opposite effect. And one of the ways that we and you can help in that is we have the Security Education Companion, and some of us have also been working with sex worker communities to try to help them be safe as far as their digital technologies in their jobs. And that's if you are somebody that has contacts with the sex worker community or is a part of that community, getting that knowledge from the Security Education Companion, sec.eff.org, helping with security trainings and helping people be safe is a really important thing to do as far as harm reduction in this time until we can hopefully eventually get a much more sane framework in place.
Thank you.
Okay, this may be outside the scope of this talk, but you mentioned...
I'm just pointing out another person who raised their hand.
Okay. You mentioned being cognizant of your threat model and even advising certain clients to not use biometrics. And one idea that I've been kind of like tossing around in my head lately is the idea of 0 days. And like you could be following all the best practices and doing everything 100% right, but we don't know about 0 days that haven't been disclosed that, do you have any considerations at that level? Like, am I just being too paranoid? I've always thought there are just certain things that should not be entered into a computer ever.
One thing I think we need to be cautious about is sort of security nihilism, that because somebody might be able to defeat my security, then we shouldn't care about it. What you want to do is do as many of the best practices as you can, understand your threat model, prepare as best possible, and then you may have to adjust that if something else comes later. And it may be true that if some Mossad or NSA ninjas come to try and find your stuff, they'll probably succeed. But that doesn't mean it's not very helpful. And to put this, if everybody is using sort of best practices, they have fully patched materials, they are protected against known threats, and somebody has to burn an O-Day in order to go after them, that makes it expensive. And so that means that even if they're not doing everything that we would want in terms of getting a warrant and going through lawful procedures and such, it's still a limitation on the ability to engage in that thing because they have to burn something to do it, because they have to put that expense out there. So even if you can be totally owned under some circumstances, if everybody is doing the best possible practices, it makes it expensive and reduces the harm.
And it only works once or for at least a very short amount of time, ideally, right? So yeah, I would love for people to only be able to burn node days to hack people. That'd be a great position for us all to be in.
And I want to add to that because the cryptography world often faces like people coming in saying quantum computers are going to break everything, just drop everything and don't enforce this encryption because it gives a sense of resigning yourself to not putting up measures. So in my security education experience, it's way more beneficial when the user at least understands or a person at least understands a base level of what's going on versus, I have no idea how encryption works in the first place. I'm really overwhelmed by the concepts and I generally don't want to engage in that and I just want it done for me. But when I see a person actually take some agency and understand the base level of it, they can at least advocate on behalf of themselves and become better self-advocates instead of, like EFF, what we do, and it's very important work, I feel. But at the same time, it needs to be disseminated with everyone to have this self-agency. So I think I often face a lot of people in my security education work where, it's like they're all watching us, they all have our data anyway, and I usually have to bring everybody back down and just say, like, these are the measurable, obtainable things you can do for now. Because me studying HPS, PKI, and all those things, like, yeah, I have to still be cognizant of where and not just resign myself to, okay, quantum computers are going to break everything. Because what I've noticed in my time is infrastructure takes a lot to actually implement and build and be sound and sufficient. And a lot of these powers that usually try to enforce these things drag their feet on actually implementing these things on a wide scale. So it's usually coming down to normally a nation state having to have that much firepower to actually do something like that versus an individual or a group.
I think we might need to stop the session, unfortunately. We have to depart. I guess the EFF will be outside to take more questions potentially.
Yeah, I think, thank you all for coming. It's a pleasure to be here. Sorry we have to end now, but we all appreciate your questions. If you have more questions for us, I think after this we're going to head up to the booth. So we have an EFF booth in the chill out room, which also is where the reception is. So it's a win-win for you. And so if anyone has any follow-on questions, we'll be up by the EFF booth. All right, thank you so much.
Thank you, everybody.